Thank you. And I want to thank the National Academy of Continuing Legal Education for this opportunity. We have quite a bit to go through today, so I wanted to get started. This is just an overview of what we're talking about. So we're going to look at an overview of Rules 7.1 to 7.6. I'm going to hand things over at that point for Brad to review some of the different marketing strategies that are listed in here. We're going to mention Alexander versus Cahill, but in a New York State case, but we're going to skip over that. And then if we have time, we're going to get into some recent ethics decisions as well. And then in terms of resources, as was mentioned, there are a lot of materials that we put together, and there's also some mention of that as well in at the end of the program too. I encourage you to take a look at it. So some background. In 1983, the Model Rules of Professional Contact were adopted by the American Bar Association. Over time, the states almost universally adopted the rules. In 2000, a comprehensive review of the rules were made. Effective 2009, and most states were in this period of between 2000 and 2010, the New York State Office of Court Administration adopted those rules. And the rules and comments found in the Rules of Professional Conduct more clearly define what is acceptable and what is not acceptable. However, what I would suggest is that since the model rules were adopted by the states, each state has promulgated its own comments, its own opinions, and made their own changes. So perhaps now things are a little less clear. And I think that was one of the intentions, as well as technological changes, the ways attorneys acquire business, that in 2018, the ABA overhauled its advertising rules, including deleting Rules 7.4 and 7.5. A few states have adopted the rules, deleting 7.4 and 7.5, including Connecticut, Minnesota, Montana, 7.4 only, Nebraska, New Mexico, and Virginia. So later on in the presentation, we'll talk a little bit about the model rules and some of the differences I saw, and we'll be looking at the Virginia rules when we do that. Some states have adopted a new Rule 7.6 that prohibits a lawyer from accepting an engagement or appointment from a judge if the lawyer makes a political contribution. And one of the things we have in our materials is a spreadsheet of each state and whether or not they have made changes, such as deleting 7.4 and 7.5, or if they also have adopted 7.6. There are additional materials that talk state by state as to in looking at the rules as to what changes were made or what the states provide for. So it's quite a bit of information. For the purpose of this lecture, we've looked at the model rules. We were looking specifically at New York State, since that is one of the states that continue to use the model rules. And again, as I mentioned, we are also looking at the Virginia rules as well. Okay. So again, over time, the rules have been modified by the states through court decisions regarding commercial speech, as well as ethics opinions and other changes that have been made. Okay, so getting into some of the rules. 7.1 and 7.3b defined. So 7.1 is your basic advertising provision. 7.3 differentiates between advertisement and a solicitation. An advertisement is basically a communications that's primarily designed to attract new clients. Okay, two major exceptions. And I would suggest to you that this might exclude 75% of attorney marketing considerations. So those are existing clients and other lawyers. So if you're communicating to existing clients, you don't have to worry about the rules. If you're communicating to other lawyers, you don't have to worry about the rules either. It gets a little bit less clear when you're communicating to existing clients, but we're also sending it to people who've contacted you, such as prospects in the past. But again, the other thing I would suggest to you is that the rules are relatively simple to comply with, at least with regards to the advertising portion of them. They get a little bit more involved when it comes to solicitations. Some key provisions of 7.1. A lawyer should not disseminate an advertisement that contains statements that are false, deceptive, or misleading. So I would further suggest to you that if your advertisements are not false, deceptive, or misleading, this is the most important rule, then I think most advertising is going to be acceptable at that point. Or violates a rule. Truthful statements that are misleading are also prohibited. So some of the examples, I have never lost a case. It's truthful, but it'd be misleading if the lawyers settled virtual all cases that they handled. Now, or if somebody like me who's been admitted for 25 years, but has handled maybe 10 cases or less, for me to say to you that I've never lost a case, it might be true, but I don't think you want to hire me for your attorney for just about anything. So here's another example. For average jury verdict for a given year was $100,000, maybe misleading if a large number of the verdicts were very small and there was one for $10 million. That specifically mentioned in the rules. An advertisement may include things such as education, bar memberships, etc., professional bona fide professional ratings as well. Names of clients regularly represented, provided the client has given prior written consent. Credit arrangements as well. Okay. Legal fees for initial consultation, including no fee, or contingent fees in civil matters, including no fee unless recovery. There are other rules that pertain to this as well, which we'll get into a little bit. 7.1c, no endorsements from clients with respect to a matter that is still pending. In New York, this is overturned by Alexander versus Cahill. If it's a paid endorsement or a testimonial, you must disclose that the person's been compensated. So what you'll often see on ads is you'll see things such as paid testimonial or actor's portrayal of something along those lines. No portrayal of a judge, also overturned. You may use actors or fictionalized cases if disclosed. So that's where the actor's portrayal comes in, or fictionalized case. You cannot rely on techniques that have no relevance to selecting counsel, also overturned. One thing that's still in the rules is advertisements shall not resemble legal documents. And there's some specific rules with respect to under the solicitation section about sending people retainer agreements and what they need to have. I think we'll touch on that a little bit if time allows. No nicknames, monikers, mottos, or trade names that imply results. This was also overturned. So you can have a trade name or a website or a phone number as long as someplace you indicate that what the actual name of the firm is. Ads may contain statements that are, okay, reasonably likely to create an expectation of results. That's absolutely fine. A comparison of the lawyer's service to other lawyers. Testimonials of former clients. Statements describing the quality of a lawyer's services. Provided that they're factually supported at the date of dissemination. That's where you might run into a little bit of trouble, is being able to factually support something. So if something's not is truthful, not misleading, and able to be factually supported, then most of the times your advertisements are going to be good. You also will see the disclaimer: prior results do not guarantee a similar outcome. Now, the two main disclaimers that are required is attorney advertising for advertisements where it's not obvious that something is an advertisement, and prior results do not guarantee a similar outcome. In almost every advertising that we do, these are relatively easy to include. It could be included in the footer. It could be included in the back of a brochure. So it's usually pretty easy to comply with both the attorney advertising statement and the prior results. So we try to include it in everything that makes sense to, be fully or additionally comply with the rules. Some of the comments: description of characteristics of a lawyer or firm that are not comparative and do not involve results are permissible. So there's some general descriptions such as hardworking, dedicated, compassionate. These are fine. But comparative descriptions that cannot be factually supported could be misleading, such as best, most experienced, and hardest working. Claims about results that cannot be factually supported may not be advertised, such as big dollars or big or most money or we win big. Like the question that I have is, what about trade names that cannot be factually supported as well? So that would seem to also not be permissible. Attorney ratings are permitted, and this is one of my pet peeves. That I have, or at least disagreement with a lot of the advertising that you see out there. Attorney ratings are permitted, provided they contain the past results disclaimer. However, they must be bona fide. They must be unbiased and undiscriminatory. They must be based on objective criteria or legitimate peer review. And I think this is something that was changed in the rules, where previously it said legitimate peer review. So there's very few things out there um, that would seem to meet that, such as the Martindale-Hubbell ratings, or you can make the argument that to some extent super lawyers would meet the peer review. And then this other criteria of objective criteria. So it's important for the attorney to look at the rating that they're being given and that it fulfill these requirements, objective criteria, legitimate peer review. I think some of the advertisements out there, draw upon the Martindale-Hubbell ratings and have their own criteria. So it's definitely something to consider. And again, it must be unbiased, based on the rating service's economic interests, and must also fairly consider all lawyers within the pool. All right, so we just talked about this. The one thing I would also note that on the one end of the spectrum, local newspaper competitions such as Best of or Pay to Play, we have to pay something to be included, or there's voting from the general public. For example, we're located in Long Island, New York. There's Best of Long Island. These are selected by daily voting, where respondents are encouraged to vote every day. They would not seem to be permissible under the rules to use that type of advertisement saying that you were voted the best lawyer of Long Island by such and such a publication. But we do see a lot of attorneys do it, and we do see a lot of attorneys spend money on these type of competitions. Again, that's something that I would normally not recommend in a marketing campaign anyway, but a lot of attorneys do it. All right, so best lawyers, that's one that I think often comes up, whether or not that meets the requirements, and promotional badges sometimes too. You have to look at the selection criteria. It's probably the thing I would recommend the most. 7.1, some key provisions. All ads other than radio, TV, newspapers, magazines, or other periodicals shall be labeled attorney advertisement. Kind of like the main part about that, it's not necessary if it's self-evident that it's an ad. But again, we'll use attorney advertising and the prior to results disclaimer on most of the communications that we work on for clients. If it's in a brochure or postcard, it shall appear therein. Some more advertising labels. It's not necessary for obvious advertisements. Again, current clients are excluded from the rules, and this is more broadly interpreted for a current client for conflict of interest purposes. These are all in the comments. Former clients, if germane to the earlier representation, are excluded. Topical newsletters is an interesting area. Client alerts or blogs intended to educate recipients about new developments in the law are not considered advertisement, but there's often these newsletters and e-newsletters are blended between advertising and articles. So they would seem to, and they do fall under the requirement to include them as attorney advertising. The rules talk about what's the primary, as you see here, newsletters, alerts, blogs that contain information predominantly about the lawyer or the firm would be considered advertising. So most newsletters and e-newsletters would do that. Redistribution of a newspaper article is advertising if the primary purpose is to obtain clients. You must comply with this disclaimer requirements and also correct any misinformation. Promotional items not considered advertising, such as your mugs or t-shirts, etc. Okay. No pop-ups or pop-unders. This is 7.1G, also removed in the rules. No meta tags or hidden computer codes that, if displayed, would violate disciplinary rules. So in the model rules that most states have adopted, and this is actually taken out of the new rules that states like Virginia have adopted, is the term specialist. So you can't say, you can't have on your website saying that you're a New York personal injury specialist. Okay. And that also means you cannot have those search terms or things such as best lawyer in New York or best lawyer in a certain other geographic area. You can't have it on your website, but you also can't have it in the metadata, the keywords that are underneath that people don't see. So 7.4 prohibits the use of the word specialist. However, the changes to the model rules adopted by the ABA in 2018 seem to allow you to call yourself a specialist if you could back that up. So there's some other specific things mentioned there that hopefully at a time we'll get to that. 7.1H, all advertisements shall include the name, principal law address, and phone number, but there's been some change in opinions, some new opinions with regards to virtual offices. You really just need to include at least in New York, a website address, at least in terms of the advertising rules. There's a mention of whether or not they comply with the judiciary law, which hopefully we'll get to those. But if we don't, there's information in the opinions towards the end of this program. Okay, we could skip through this. We already talked about that. Some other selected provisions, 7.1J, the advertisement of fees. When advertising fixed fees, this is kind of interesting. You must have available to the public a written statement describing the scope of the services. Those services shall include all that is reasonable and necessary under local custom. So advertisements also have to be pre-approved by a lawyer of a firm. This is in the rules. From time to time, marketing companies, I think, it's sometimes more efficient to do, to work on behalf of a client without getting pre-approval. So that's something to consider. Advertisements shall be retained for 3 years. Emails and computer access communication 1 year. Websites have to be retained for 1 year from the time of publication. Redesign or extensive content change. The rule also requires that a site be preserved no less frequently than 90 days. So one of the things that we do is that we have a backup on our server where our attorney websites are hosted that provides for a 90-day backup, and it creates a separate file for them. So that's how we comply with that rule on the websites. Otherwise, I guess you could also print it out every 90 days to comply with that rule. Here's some additional selected provisions on the 7.1L. When advertising an hourly rate, fixed fee, or schedule, you shall not charge more than the fee advertised unless the client agrees in writing that the services to be performed were not legal services referred to implied in the ad and that are different from the fee arrangement. So if you're advertising a fee, you'll be bound by that fee for a period of time, depending on the frequency of the ad. So it's somewhat common sense, but if you're doing it more than 1 month, if the ads, let's say it's in a weekly newspaper or magazine, then you'll be bound to that for no less than 30 days. If monthly or longer, then the next issue. If no succeeding issue, then a reasonable time, but no less than 90 days. If it's a broadcast, like a TV thing, no less than 30 days afterwards. One example would be the phone book. You would be bound until the next issue. Now the phone books are going, there's a few of them around in some local communities, but I guess the next issue might be forever at some point. But of course, it would be a reasonable time. And generally phone books came out once every 6 months and once a year. So it would be a year if you're advertising the phone book. 7.10, a lawyer shall not give anything of value to representatives of the press, radio, TV, etc., in return for publicity. Now, this calls into question of like the Super Lawyers magazine. Every page, but whether or not there's articles in the publication in addition to ads, and so how are the articles selected? Generally speaking, attorneys pay for different types of advertisements and the articles that appear. But the way that Super Lawyers gets around that is that every page has attorney advertisements disclaimer on it. So pretty much all the content in there is an ad. 7.1P. This is judiciary law, New York State 4883. You must not state or imply that a lawyer or firm's ability to advance or pay costs is unique or extraordinary unless you can demonstrate that fees are objectively unique or extraordinary. So it doesn't prevent you from discussing fees or expenses. You just can't state or imply that they're out of the ordinary. So you can make obviously you could say that there's no fee unless you recover money, such as in a contingency case, but you can't say that you're the only one doing that or this is an extraordinary offer and why you should be selected as the person's attorney. A lawyer may accept employment, 7.1Q. This was a rule that was added at some point. A lawyer may accept employment that results from participation in activities designed to educate the public, to recognize legal problems, to make intelligent selection of counsel, or to utilize legal services. And in fact, this type of participation is encouraged. 7.1R. A lawyer may speak publicly or write for a publication on legal topics, so long as the lawyer does not undertake to give individual advice. Okay. Public relations, this is comments, public relations in programs are not considered advertising. Talks are ran by lawyers or non-lawyers. The attorney should, however, this is in the comments, should caution a participant not to attempt to solve individual problems on the basis of information contained therein. So you should disclaim that. Nonprofit sponsorships are not considered advertising. And the sponsorships may even contain information about the firm, contact information, and practice areas. 7.2, a lawyer may not compensate. This is a payment for referrals. 7.2, a lawyer may not compensate or give anything of value to a person or organization to recommend or obtain employment by a client as a reward for having made a recommendation resulting in employment by a client, except you may refer clients to a non-legal professional service firm pursuant to a contractual relationship in accordance with Rule 5.8. However, such referral shall not include monetary or other tangible consideration or sharing of fees. And this rule differentiates from 5.7, which is if a law firm is providing those non-legal professional services. So we have some more mention of these two rules later on. But I would encourage them to, attorneys, if they're looking at the attorney advertising rules, to also take a look at rules 5.7 and 5.8. A lawyer may pay fees or dues charged by a legal assistance organization or referral fees to another attorney as permitted. One of the things I came across in looking at some opinions from other states, I believe it was in context of some of the changes with AVO, is that I think it was Illinois, and this is, by the way, this is in your materials. It's a blog article, and one of the states had suggested, and I think it was Illinois, that what's the difference between paying a fee or sharing a fee with a legal assistance organization or as compared to sharing it with AVO. But we'll talk about that later, hopefully. That those type of fee arrangements are not in accordance to the rules. A lawyer may be recommended, employed by, or may cooperate with a legal aid office, military assistance office, etc., legal service plan. 7.2 does not prevent you from paying for advertising, as well as paying employees, agents, or vendors that provide marketing or PR. Thank goodness on that rule. Absolutely. A lawyer may pay others for generating leads, provided the lead generator does not recommend the lawyers, and payment to lead generators consistent with Rule 1.5, and that's division of fees. To comply with 7.1, a lawyer may not pay a lead generator that states or implies as recommended lawyer. There's a number of ethics opinions on this, including the AVO decision that we talked about. And I pulled some and put them towards the back of this presentation that we'll get to after Brad speaks about marketing techniques. But I encourage you to take a look at those and look at those opinions as well. The code prohibits a lawyer from making or soliciting a political contribution if a disinterested person would conclude that the contribution is being made or solicited for the purpose of obtaining or being considered for government legal engagement. So the comment discusses this further. However, this is basically the subject of that new rule 7.6, but in the pre-existing model rules, it's covered under 7.2. All right, 7.3. This is where now we're talking about solicitations, which are a form of advertising. All right, so but a solicitation requires some additional rules to be aware of. A lawyer shall not engage in solicitation by in-person telephone contact or real-time computer access communication. So this is the in-person solicitation being prohibited, unless the recipient is a close friend, relative, former client, or existing client. Okay. So the in-person solicitation was extended by technology to chat rooms and instant messaging and so forth. The pop-ups that are live response are not considered real-time communication, such as like a live chat. Okay. Right. So the key thing there is like who's initiating the contact. If the potential client, prospective client, is initiating the contact, that seems to be permissible or is permissible, as compared to if the attorney is initiating the contact. That's a differentiation. Okay, so 7.3b, but if you're engaging with people online, it's probably, even like let's just say on Google Business, it's probably best practice to ask the person to call the office with questions or to schedule a consultation. 7.3a2, a lawyer should not engage in a solicitation by any form of communication if it violates the other rules. The recipient makes it known they don't want to be solicited. The solicitation involves coercion, duress, or harassment, or the lawyer knows that the person that they're contacting makes it unlikely that they are unable to exercise reasonable judgment. Okay. If the lawyer intends or expects, but does not disclose, that the legal services necessary to handle the matter competently will be performed similarly by another lawyer who is not affiliated with the soliciting lawyer as a partner, associate, or counsel, you need to disclose that. Right. And that's probably one of the reasons why you'll often see on pools or referral services. You see this a lot in the products liability area, mass torts, that it would indicate on there that the person sending out this solicitation may not be the person handling it. Okay, and again, this refers to solicitations, not advertisements. Solicitations also trigger filing requirements. Okay, so the best way to differentiate between a solicitation, an advertisement, and a solicitation is solicitations or advertisements that are targeted as specific recipient or group of recipients, family, etc. 4 criteria. It's an advertisement. Purpose is to persuade recipients to obtain a lawyer, motives to make money, and directed to targeted to a specific recipient and group of recipients or their family members or legal representatives. Now, in the newer model rules from 2018, it says a known recipient or is known to be in need of legal services. So I think that helps to define things a little bit better with respect to solicitations. That somebody you know needs legal services is what makes something a solicitation, at least under those new advertising rules. So obviously you're dealing with a fixed list when you're dealing with solicitation for the most part. It's usually direct mail, but it could also include web, newspapers, and TV if applying to a finite group of prospects. Some of the filing requirements: copy of solicitation shall be filed with the disciplinary committee. Transcript of audio or video as well, if in another language, an English transcript is required. Copies must be retained for 3 years. If the solicitation is directed to a predetermined recipient, a list containing the names and addresses shall be retained. Doesn't have to be filed, but retained for at least 3 years following the dissemination. The filing requirements don't apply to websites unless it is designed for and targeted at a specific client affected by identifiable event. And I guess you could see this occur in regards to certain mass torts or products. A written solicitation shall not require the recipient to travel to another location other than the place where the person receives mail or that requires a signature. So you can't use certified mail overnight services requiring a signature. There's a 30-day, even within the solicitation, there's a 30-day prohibition from soliciting personal injury or wrongful death claimants. 15 days if there's a a filing requirement, like a notice of claim. The rule also applies to defense counsel. Does not apply to PI or wrongful death arising from a common cause, but at disparate times and places. The 30-day rule is event specific. Okay. Checking on time. If an ad makes no express reference to a specific incident and is disseminated, it does not violate the rule, unless it's directed to a specific recipient with the knowledge that they are a victim, even if it's part of a mass mailing. So you can't do a mail-in to, let's say, where there's a victim of a personal injury matter. You can't send a mail-in out to the entire zip code looking to reach them. Or let's say more reasonably a carrier route, which may only have like 500 houses in it, or a smaller geographic area. And the same could potentially apply for digital purposes within the 30 days as well. Okay, so even if it's a mass mailing or a broader based digital advertisement that you're trying to reach a specific recipient. In these circumstances, in-person rules apply even if the recipient is a close friend, relative, or former client. Solicitations to a predetermined recipient, if prompted by a specific occurrence involving or affecting the recipient, shall disclose how the lawyer obtained the identity of the recipient and learned of the recipient's potential needs. So if you're sending out a letter or a postcard, you would need to include in there that, let's say that they're and I think there's some examples here. So you would have to note that you learned that they may have been a victim of a personal injury matter, but also things such as a bankruptcy filing or a lis pendens filing. You would have to mention in the solicitation how you got that information. Here's references earlier on. If a sample retainer is included, the top of each page shall be labeled sample and read in equal size to the largest type size with the words do not sign in the signature line. 7.3H, any solicitation shall include the name, principal address, and telephone number of a lawyer or firm whose services are being offered. And that just prompted me to think about virtual offices as well. So that's a good question, I think. Provisions of the rule shall apply to lawyers not admitted to practice in New York State and who solicited retention by residents in the state. Okay, so it applies to out-of-state attorneys as well. Okay, again, does not require the same thing of advertisements. All right, we're shifting now to Rule 7.4. Again, worthy to note that 7.4 and 7.5 were deleted in the new model rules, but again, only 6 states have adopted that, looks like, based on our research. Okay, a lawyer may publicly identify one or more practice areas, provided that the firm shall not state that the law firm is a specialist or specializes in a particular field. So this is, again, another difference between those new model rules too. Those admitted to practice before the U.S. Patent and Trademark Office may use the designation patent attorney or a substantial similar designation. It's become common practice, for somebody to say that they're an elder law attorney, et cetera. So, I think that those are also permissible. There's I believe, some ethics opinions on that too. A lawyer may state that they have been recognized or certified as a specialist only as follows. An organization approved by the ABA, along with disclaimer provided in 7.4, a certification in another state, provide inclusion of the disclaimer in 7.4C2. 7.5 outlines the use of websites, business cards, announcement cards, office signs, and letterhead. I don't think we get too much into detail here. Some of the things I found interesting: a lawyer shall not practice under a false, deceptive, or misleading trade name, domain name, or name that is misleading as to the identity of the attorney. So some of the things here, a legal aid, a legal service office, legal assistance office may only be used by a bona fide legal assistance organizations. I was reading in some, it was probably the comments, and I think we touch on this later, so in the comments regarding the the 2018 model rules, we'll call them, that you can use a legal clinic. However, they gave the example, and hopefully we'll get to it, Springfield Legal Clinic. And you might need a disclaimer there saying that it's not a governmental office under those circumstances. Cannot use the term not-for-profit unless the law firm qualifies. That seems rare. A law firm may not include the name of a non-lawyer in the firm name. It shall include PC, LLC, and LLP in the firm name if it's one of those. And you may use a phone number that contains a trade name, a domain name, nickname, or motto that doesn't otherwise violate the rules. A law firm that has a contractual relationship with a non-legal service may not include in its firm name the name of a non-legal service firm. May not use the name of a judicial, legislative, or executive office holder while during the period where the lawyer is not active and regularly practicing. So, there's something like this seems to come up often where elected officials are also members of law firms. Just something to be aware of. If they are, then they should be continuing to practice. It is not false, deceptive, or misleading for a firm to be designated by the names of all or some of its members or by retired or deceased members where there's been a continuing line of succession of the firm's identity. So obviously there's many firms that have been around for almost centuries that continue to be named by some of the original partners. What this rule says is that they should have always had that name in there, and it shouldn't have been added later on. There has to be a continuity succession in the firm's identity. May not use a name that implies a connection with a government agency or state is a nonprofit unless it qualifies. So it's in the comments. May not use a name that includes the words legal services, legal assistance, legal aid unless a bona fide organization. Communication signs, etc., may include non-legal business conducted by a lawyer. All right, so that's permissible. A lawyer may be designated as counsel, special counsel, or of counsel on letterhead if there is a continuing relationship with another lawyer or firm. A lawyer or firm may be designated as general counsel on the stationery of a client. So if you do work for a corporation, a business, they can include you as being designated as general counsel. Some trade name comments. It's proper to practice under the lawyer's or law firm's own name, initials, trade name, domain name, abbreviations, areas of practice, and variations or combination of those. So some of the examples given, if Abel and Baker are attorneys' last names, you can have things such as Abel Baker real estate lawyers, A and B real estate lawyers, dirt lawyers, so that's a trade name there. Domain names such as realestatelaw.com, or something such as like Albany personal injury lawyers. Do all that.
John, we had a question here. Somebody was a few slides back about the statement that specializing in is prohibited, but it is a statement such as focusing on certain practice areas okay.
Yeah, that's I didn't see it in the specifically in the comments, but it's become very regular practice for somebody to refer to himself as, let's say, especially like an elder law attorney or a personal injury attorney in advertising. So especially considering I believe the model rules specifically say that the new model rules of 2018 specifically say that it's permitted, but I think it's become quite common practice to do that. The New York rules, from what I could tell, still say that it's you can only use that for a patent law attorney. But here again, here's this specific 7.5 Abel Baker real estate lawyers. If you're saying that I would think that it's, and right down here, this is specific in the comments, Albany personal injury lawyers. So saying that somebody is a particular attorney is a personal injury lawyer or a personal injury lawyer so-and-so, I think that's that would be by implication permitted at this point in time.
Sounds good.
And it's become such common practice as well. I think that's probably an overriding thought there. Trade names or domain names may not be false, deceptive or misleading. Cannot use a trade name or domain name that such as win your case or winyourcase.com. Telephone numbers similar to trade names may use a combination of a firm name and numbers, such as 1-800-ACCIDENT. You will have seen these. May not use something like 1-800-WINNERS, 1-800-to-win-big, or 1-800-to-get-cash. 7.5C, lawyers may not hold themselves out as having a partnership with one or more lawyers unless they are in fact partners. So this has come up a couple of times in our experience, where, especially where there's joint, firms might join together or have a strategic partnership in mind to handle certain types of matters. That's come up. A partnership shall not be formed or continued among members licensed in different jurisdictions unless all enumerations of the members and associates of the firm on its letterhead make it clear the jurisdictional limitations on those members and associates. So I've seen this a few times. We have a few clients that practice in multiple states, and sometimes when you look at your letterhead, and in many cases they won't do this on the letterhead, they just won't include the partners and associates. But when they do, sometimes it becomes, I guess, somewhat of a puzzle to figure out who is, which attorneys are admitted to what states. And you see all different types of asterisks, pluses, crosses, et cetera, to denote that. And I think it just gets too busy at that point as well. You need a second sheet of paper to get everybody on there. Partnership name may be used in each jurisdiction, so that's fine. Here's the model rule 7.6, and our chart, our spreadsheet talks about the states that have adopted 7.6, and it is incorporated into one of the other rules. But political contributions to obtain legal engagement or appointment by judges. Some states have adopted 7.6. Prohibits a lawyer from accepting an engagement or appointment from a judge if the lawyer makes a political contribution for that purpose. Okay, 5.7, just want to check on time briefly. Okay, 5.7, again, 5.7, 5.8 are related to, I think more and more how law firms are functioning. So I think they're important to look at. These are services that are not distinct from legal services. All right. This rule 5.7, you're talking about your own law firm, whereas 5.8, you're talking about a non-affiliated, or I guess affiliated, professional service provider. That's not your law firm. So 5.7 talks about services that are not distinct from legal services. Where legal and non-legal services are not distinct, the lawyer providing the non-legal services is required to adhere to all the requirements of the rules with respect to non-legal services. Okay. Unless the client understands that the non-legal services are not subject to the attorney-client privilege and they are advised in writing. So there's a number of conflict of interest considerations here that are addressed in the rule and the comments. Again, just want to try to alert you to this so you can look at these. But I think these are pretty popular rules or ones that attorneys look at a lot. This 5.8, now this is the contractual relationship between lawyers and non-legal professionals. So this is a different organization, a separate organization. You cannot share legal fees with non-legal professionals. It's part of the rules. Common rule, must disclose the contractual relationship before referring somebody to a non-legal professional service firm. Must provide a statement of client rights and cooperative business arrangements. Lawyers may enter into interprofessional contract relations provided that the non-legal professional firm does not own, control, or supervise or manage the lawyer's or law firm's practice. Okay, so the professional service firm can't have control or have ownership of the law firm, and I think that's prohibited in the rules anyway. 5.8 comments. Law firm may not include in its firm name the name of the non-legal professional service firm. Contractual relationship may provide for reciprocal referral of clients by and between the lawyer or law firm and the non-legal professional or non-legal professional service firm. Referral should be made only when requested by the client or deemed reasonably necessary to serve the client. And referrals may not be on an exclusive basis. Okay, so looks like we have some time here. Some of the I just in going through the 2018 model rule changes, I looked at the in particular the Virginia rules. Now, a few states have adopted these new rules since 2018. Deleting 7.4 and 7.5, including Connecticut, Minnesota, Montana 7.4 only, Nebraska 7.5, New Mexico, and Virginia. A few other states are indicating these rules are reserved, including Arizona, Oregon, Tennessee, and Washington. So that's if you're in those states, is something to look at as well. Rule 7.4 and 7.5 again were deleted. They deal with areas of practice and specialty, and lawyer and firm names deleted. Okay, so some of the key differences between the existing rules in Virginia, and these rules are, by the way, I think the New York rules are about 20 pages long. The Virginia rules, that I had them over here, they're about 6 pages. So it definitely consolidates, and even 7.4 and 7.5 are incorporated into some of the other rules as well. This is just some of the things I thought were interesting in the Virginia rules. Is Rule 7.1 Common 4, areas of expertise and specialization. A lawyer who's a specialist in a particular field of law by experience, specialized training, education, or is certified may communicate such specialty. So, for the longest time, that's one of the key words that we couldn't use, that somebody's a specialist or somebody's an expert. Doesn't address the word expert, but specializes in, at least under these rules. And in Virginia, you could talk about being a specialist, provided that you have experience or training, or certification. You could do that. 7.1 Common 5 under firm names, you may use legal clinic. I mentioned this earlier. If, for example, Springfield, you could use something like Springfield Legal Clinic. You may need a disclaimer saying that you're not a public legal aid agency.
If you're in a jurisdiction that requires a verification code, please write the following code word down. DUCK. D-U-C-K. DUCK.
7.3. This I thought was helpful, directed to a specific person known to be in the need of legal services. So I think that's a little bit narrower or better defined than the model rules in the other states, such as New York. And again, states may have made these changes themselves. I encourage you to look at the materials and look at the comparisons and look at your own state's rules. Obviously, for this lecture, we couldn't do that. It's quite a bit of information, quite a bit of difference among 50 states. So some other things I noticed: written materials shall include the words "attorney" advertising material on the outside of an envelope or beginning of a recording or electronic solicitation. So this reminds me of something. Back in the mid 2000s, the New York rules had not been adopted yet, and there was a draft, I remember, that was much more draconian, much more restrictive. And one of those proposed rules at the time had a requirement that you had to include attorney advertising on the outside of an envelope in a direct mail piece. But the adopted rule in 2008, I believe, in New York, said that you only need it inside of a letter, on the letter, and as well as the prior results if it applied. So I did a mail-in for a New York City firm. I believe it was commercial real estate tax certiorari, and it was the only time I've ever been called out by the disciplinary committee, and they asked me to get on, do a conference call with the attorney that we worked with, and they said that your mail-in didn't comply with the rules. The rule says that it needs to be on the inside of the letter, on the letter, not on the envelope. And I was trying to explain to them, well, by putting it on the outside of the envelope, you're alerting the potential client, hey, this is a mail-in from a lawyer. And most people, I think, you get a letter from a lawyer. What's your first reaction? Well, I'm being sued for something. Obviously, lawyers and law offices get letters from other attorneys all the time. But lay people, the general public, they see that would be one of the first concerns that come to them. And now so under those circumstances, by having the word advertising on it, on the outside of the envelope, they can decide whether or not they want to look at it or not. So I thought it was even greater compliance, but in the end, all they really wanted to say is that we wouldn't do this again. I gave up my argument, and we all moved on. But this is interesting that in the Virginia rule, it has to have the advertising material on the outside of the envelope. So I think that would be a good change, that the public would appreciate. 7.3, comment 4, paying others to recommend a lawyer. This again relates to a lot of the different, opinions that have come out. This kind of relates to the Avo case as well. To comply with Rule 7.1, a lawyer may not pay a lead generator that states, implies, or creates a reasonable impression that it's recommending the lawyer, is making the referral without payment from the lawyer, or has analyzed a person's legal problems when determining which lawyer should receive the referral. So, on the legal directory side of things, on the websites, the referral websites, the key thing is implying that they've identified the best lawyer for you and sharing the fees. Those are the two things that would seem to prohibit the rules. So let's see. This is Alexander versus CLE. This is the New York State case that resulted in a lot of the rule changes. I'm just going to completely skip through that. We planned on it. We just have full pages here. All right. So Brad, we're about 50 minutes in. You're up. Okay.
Gotcha. Hi, I'm Brad Sweezy. I'm the co-founder of Avocati Marketing with John. I am not an attorney. I did go to Georgetown University Law, but I do not practice, and I actually have a year to go, which I'll never finish. So I've worked in and outside of government, in the corporate sector as well, worked at the Food and Drug Administration in DC, et cetera. So I like to have a more strategic approach to things because I think that's what we need for law firms to grow practically. So we're going to look at a bunch of different things related to marketing. And the first thing, which is often neglected, is strategic planning and research. And one of the key things you do is budget, right? I mean, typically when you're looking at a goal in mind, you have to resource properly to make that goal. And I think a lot of law firms will look at marketing and just, throw money at something and not really look at how much money do they need to do to get where they need to go. So that's important. The second thing is client insights. Oh, there you go, John. So you want to look at some things, demographic factors. There's age, gender. You can look at household income. You can look at where they're located, primary language, all these kind of factors, even cars they drive, et cetera. You can really narrow down into what kind of client you want to get.
Yep.
So acquisition analysis, when you're doing any type of marketing, you really want to know where are your leads coming from. And a lot of times when you talk to attorneys, they'll go, well, we ask them, and the person says. That self-reported data is often somewhat inaccurate because they saw you online or something like that. And it's a problem with other types of things out there. So client identification. Who's your ideal client? Who's your ideal client? Who's your most profitable client segment right now? And do you want to continue on that path of those current clients that are profitable? Or do you see changes in the law happening that you want to start getting ahead of that and acquire, a different client base? So goals, strategic goals, I headed it for the National Guard Bureau in Washington, 360,000 people, and I was in charge of strategic communications. We used to call it strategic reactionism. It's very hard for organizations to plan 5 years ahead of time. But it's nice if you can do that. Where do you want to be 5 years from now? A more realistic goal is 6 months and 1 year, because those are benchmarks you can wrap your hands around, et cetera. So another way to grow is attorney referrals, right? So you want to engage with those attorneys and bar association events, CLE events, do a CLE, for example. There's direct outreach, mail, e-newsletters to legal peers. You can include them when you send your newsletters, your e-newsletters to people. LinkedIn is pretty popular for people, not only when they're looking for a job, but, to reach out to other attorneys. If you see them post something that's interesting, comment on it. You can build a good dialogue that way. Then you got professional referrals. If you're something like an estate attorney, a probate attorney, et cetera, maybe you want to have relationships with CPAs around your area, those kind of things. So really, you can target those. You can advertise in that. I had a client a few years ago who wanted to target veterinarians. He was a CPA. Well, you can join that veterinarian organization and then participate as a non-member and grow that way. And you want to take active role in professional and charitable events. I'm on a board of a nonprofit, and the other board members, I'd say about 60% of them are attorneys. And one of them is running for judge this year in November. So it's a good way to do things, network your business with not only with attorneys, but, non-attorneys as well.
Yeah, I just want to add, Brad, that, very often you want to be in front of the people who are your referral base. And that's where the chambers of commerce or broader based networking organizations, when you're not in front of, you want to be, if you do work for restaurants, then you want to be a member of the restaurant association, as Brad mentioned, as an affiliate member. Rather than, so you want to be in front of your networking group, because networking takes a long time. Driving to events, going to events, becoming more involved. So it's important to pick, and attorneys are generally very busy. So you want to pick the group that's going to get you the best return on your investment.
Yeah. Yeah. Because the average 1 hour networking event is probably going to take you 3 hours, realistically, by the time you're, getting there and back. So you really want to be picky where you get involved in. So why geographic reach? If you want to expand your market, you want to do radio, TV ads, Google search ads, which we'll talk about later, are great ways to do that, to target a particular market with a particular practice area.
Yeah.
On the local focus, you've got local newspapers. Now, I know a lot of people don't get printed papers anymore, and that's true, but a lot of people who are local newspaper customers actually read the online versions now, and now most of them are doing those firewalls, so you have to pay to read them, but a lot of people are doing that. So you want to use the local papers no matter what format they have, and direct mail is another great way to reach people, especially if you get to the elder law type of thing. My parents are in their 80s. They love mail. Getting mail is one of those things they do. They still don't necessarily wrap their arms around email. At least my parents don't.
Besides talking to you, it's probably the thing they look forward most in the day.
Yeah.
Is the mailman's here, right?
Yeah,
So,
exactly. And they'll hold up those postcards and flyers they get. So you definitely want to not rule that out. And digital ads, we'll talk all about those later, in social media as well. And you can target, who do you want to target? And pretty much nowadays you can target just about anybody you want. Now, there are some things where you can't necessarily target because of, various laws, et cetera, but you can still kind of narrow in on what your focus is. For example, we could focus on, we want managing partners. We want to reach out to managing partners at law firms, and we can do that. So earned media strategies. So what earned media is, basically, you earn it by sweat equity, so to speak. You're not paying for it, but you're trying to use the media, for example, and become a source for them that benefits the reporters who are frequently under the gun. Reporters are usually deadline driven. They've got to get something quickly. Now they have to do things very quickly. The print journalists now also have to write stories, post online, get little video clips and all that kind of stuff. And so you can be part of that conversation where you're a go-to person for somebody who's got a question. They know you're going to respond, and they know you're going to give them something good. So that's one thing, but you can look at some of these other ways to do it. Like if you're in a community event and you're doing a charitable involvement, you need to publicize that. That's where a firm like us helps you publicize those things, where you can participate in the conversation that's going on.